Good morning everyone. I am Aparimita of 10th semester BBLLB and today I will be talking about client counseling and alternative dispute resolution. The word counsel has its origin from the Latin word consilium, which means advice. According to Black's Law Dictionary, counsel means advice and assistance given by one person to another with regard to a legal matter. Counseling is one of the primary functions of an advocate. Traditionally, legal counseling was viewed as the advocate advising the client with regard to his or her legal problem. But with changing times, there has been a development of a more client-centered approach to counseling. In client-centered counseling, the advocate assists the client in a way he or she wants, rather than the advocate taking decisions on behalf of the client. While counseling the client, the advocate should focus on creating an atmosphere for the client wherein he feels comfortable to share all the information regarding the case. While communicating the legal advice to the client, the advocate shall be very careful and shall communicate in the client's language. The advocate should be non-judgmental, supportive, and accepting. The advocate should assist the client in understanding his rights and duties and shall explain to him all the various legal recourses that are available to the client. In doing so, the advocate informs the client about the various modes of ADRS that can be availed in that particular case. Alternative dispute resolution refers to the alternative modes of adjudicating the dispute apart from the conventional mode, that is litigation. One of the main benefits of ADRS is that it is free from the shackles that bog down our normal legal proceedings, such as judicial delays, surmounting expenses, etc. The ADRS methods involve a neutral third party who helps the parties to resolve their dispute by either reaching an agreement or facilitates the parties in finding a solution to their legal problem. There are 5 modes of ADRS: arbitration, mediation, conciliation, negotiation, and lok adalat. Arbitration is a quasi-judicial trial procedure of adjudicating the disputes. Mediation is a process in which a neutral third party, mediator, works with the parties and helps them find a solution to their dispute which is acceptable by all the parties. Conciliation is a process in which a neutral third party, conciliator, facilitates communication between the parties and helps to settle their disputes. Negotiation is a process of self-counseling to resolve the dispute. In India, negotiation does not have a statutory authority. Finally, in lok adalat, if the court is of the opinion that the dispute between the parties can be resolved amicably, the court itself will refer the parties to lok adalat. In the upcoming series, the students of 10th semester BA and BBLLB, are going to demonstrate the various modes of ADRS. And we'll also show how an advocate uses the platform of client counseling to promote ADRS. Thank you.
Good morning. This is the first video of a client counseling session in the alternate dispute resolution system series. I'm Adya Bojama. My friends and I from the 10th semester are putting forth a client counseling session emphasizing the conciliation mechanism under ADRS. A little insight on conciliation. Conciliation is a confidential, voluntary, non-adjudicatory, and non-adversarial dispute resolution process where an impartial third party enables the disputing parties to a negotiated settlement. Like part 3 of the Arbitration and Conciliation Act deals with conciliation. Like any ADR process, the sanctity of conciliation is the mutual determination of the parties to resolve their disputes amicably through ADR mechanism. If the parties reach an agreement on settlement of a dispute, a written settlement agreement is drawn by the parties and signed. The parties may also request the conciliator to draw or assist them in drawing up the agreement. Once the parties sign the settlement agreement, it becomes final and binding on the parties and the persons claiming under it, respectively. Let's proceed to the facts of the case. Ms. Kavya is an employee at the company CM Limited. In the employee-employer contract of CM Limited, the employer promised to pay the employee traveling expenses and other expenses every month of rupees 10,000, which the employer failed to do so for 7 months. Last month, Kavya instituted a case on this regard. When Ms. Kavya initially visited the firm, both the counsels advised her on alternate dispute resolution system. However, Ms. Kavya was turned on litigation as she was sure to get money outstanding to her by this method. The advocates agreed on fulfilling her requirements. Ms. Kavya approached her advocate after getting a letter by post through her employer. The letter stated the employer's preference to settle this matter out of court through conciliation and affirmed to provide Ms. Kavya the relief she sought. Hence, the client in this second sitting asks the counsel to explain the conciliation process, and additionally, the counsel reasons as to which is better, the ongoing litigation or conciliation. Here, Ashika is the counsel and Kavya is the client. Let's proceed to the scene.
Good morning, ma'am. May I come in?
Yes, good morning, Miss Kavya. How are you? Please sit down.
Thank you. I'm fine, ma'am. I wanted to bring to your notice an issue pertaining to my case regarding about the enforcement of the contract between my employer and I.
Yes, ma'am, I'm aware of the case. But before you tell your issue, I'd like to state that our confidentiality agreement is still binding. And also, we are not charging any advocates fee for this session. As my co-counsel, Ms. Sanjana, spoke to you last time, we only collect advocates fee during the beginning, that is when you instituted your case. Thus, this session and further sessions are free of charge.
All right, ma'am. Can I also speak to Advocate Sanjana, who initially handled my case?
Unfortunately, Advocate Sanjana is not in town for a period of 2 weeks, but I've been briefed with the same and I'm aware of your matter. So once she's back, I shall brief her the same.
Very well, ma'am. As an executive level employee, I draw a salary of 23,000 a month in my employer's company, CM Limited. According to the employment contract, I was promised a monthly sum of 10,000 rupees for traveling and other expenses. However, the employer has failed to pay the same for the past 7 months. Last month, after we served notice, a case was instituted in this regard through Advocate Sanjana.
Okay, yeah, I checked the case diary and your case is posted for next Friday and the stage is for your employer's reply. So kindly tell me the current issue, what you are facing, Miss Kavya.
So, ma'am, yesterday I got a letter by post from my employer, and the letter stated that we can settle this matter out of court by conciliation and that my employer will ensure my relief is granted. I remember the first time I visited this firm, both the advocates suggested on conciliation, and I thought to myself that it was a good option. So I'm considering it now. But can you please explain the procedure to me again and also suggest which is better, the ongoing litigation or conciliation?
Sure, ma'am. May I just summarize what you stated just for the sake of clarity? So you stated that you were aggrieved by the fact that your employer did not pay you certain expenses, including traveling expenses for a period of 7 months, and that amounts to 10,000 rupees per month, and that is also in your contract. And since you agreed by that, our firm instituted a case as you came earlier. We instituted the case in the first session, and now you further state that yesterday you got a letter by post from your employer, wherein he states in that letter that he is willing to settle this ongoing dispute through conciliation. Am I right?
Yes, that's right, ma'am.
Okay. May I ask if you have that letter, Miss Kavya?
Yes, I do have it with me.
Okay, you can send me a copy or you have it.
Yeah, I have it right now.
Okay, thank you, Kavya. I will go through it. I need to go through it in depth. I can see the conciliation mentioned. So so you asked me what is conciliation and its advantages. So conciliation refers to settling of a dispute without litigation. It is a non-adversarial system of resolving a dispute, and it involves a settlement procedure wherein an impartial third party, who is known as the conciliator, steers the disputant parties to reach a settlement and to reach a agreement as to their dispute. So, labor disputes in particular are encouraged to be settled by conciliation. In fact, certain employees and workmen are bound to conciliate. They have mandatory conciliation when they are drawing a salary of less than 18,000 rupees per month. But since you are an executive level employee drawing a salary of over that particular threshold, you had a choice between this particular conciliation as well as litigation. So I just wanted to let you know that.
All right, ma'am. Is there any law for conciliation and is it binding?
Yes, coming to that. So section 61 of the Arbitration and Conciliation Act of 1996 gives the application and scope of conciliation. And it further points out that the disputes must arise out of a legal relationship. In the instant case, the legal relationship which is established by your contract between you and your employer. And so this gives you a legal right, the legal right being the right to sue or the right to be sued.
I understand, ma'am. But is the decision of the conciliator binding on the parties?
Yes, Ms. Kavyas, I was coming to that again. So, according to Section 73 of this Arbitration Conciliation Act of 1996, it states that the decision of the conciliation proceedings shall be final and it is binding.
Okay, ma'am. Could you please kindly explain the procedure which the conciliator should follow?
Yes, Ms. Kavya. So there is no established procedure, and he shall just assist the parties to reach to a settlement, and he will be guided by the principles of objectivity, fairness, and justice. And conciliation proceedings shall commence when and one party accepts in writing the invitation to conciliation. So either party can send an invitation, and once it's accepted, the proceedings shall begin.
Okay, ma'am. Can you tell me approximately when these proceedings will come to an end?
Yes, so your employer, it can be settled at any stage, and the conciliator will make proposals for settlement at any stage, and you can accept those settlement terms as and when it is brought in. Now, since your employer already agreed to this particular fact, you will not have a problem because he's given it in writing, right? So he also is intending to solve the problem. So that will be done at the earliest when you all come together.
Yes, ma'am. I just want the relief. It is what was promised to me.
Yes. So you also asked me the advantages, Kavya. So the advantages of conciliation definitely outweigh the aspect of litigation because one, as an ADR, it is cost effective and it saves a lot of time as there's no court fee as in litigation. Secondly, it does not prolong your case as compared to litigation. Cases take years and years to get over, and conciliation does not create a feeling of ill will. Now, this is very important because you and your employer meet on a daily basis, so you can establish your relationship well even with this particular dispute. And also, it can be terminated as and when required by the parties, as I stated earlier in the procedure. And another important thing is you have your absolute privacy, unlike a litigation case where it's this open court and everyone can hear what is going on. And also, lastly, it is a flexible procedure. It's not bound by CPC or the Evidence Act. There's no stages as such. It's very flexible, and at any point, as I stated earlier, it can be settled. So that's in your best interest. I suggest you to choose conciliation.
Okay, ma'am, I do not wish to continue with the litigation case anymore and have decided on conciliation. But what will happen to that case?
Yes, Ms. Kavya. So the courts always prefer out of the court settlement and they encourage the same. So I shall inform your decision and that shall be taken care of.
Okay, I was very worried, but now I feel like conciliation is a good option for me. So I'm ready for the proceedings. Can you please make the arrangements for the same?
Yes, indeed, ma'am. I shall keep you I shall keep you informed on this, and I shall engage a conciliator also, and we'll look into the procedure further, and we'll bring in that invitation so that the process can start as soon as possible. Further, you can contact me any time after 6:30 p.m. if you need to do so, and we'll make arrangements for all the procedure. Don't worry, okay? And let me know if you have any other questions, any other queries, anything.
I'm clear. Thank you, ma'am. Today's session was extremely helpful. Thank you once again.
Always there to help you, Ms. Kavya.
Thank you, everyone. I'm Sanjana from 10th semester BA LLB, and I'll be giving the conclusion for the role play. So I hope our session on the conciliation between the lawyer and a client was comprehensive and clear. Now, when you look at it generally, the clients are unwilling to go through ADR mechanisms, or sometimes they're completely unaware of it. Hence, the counseling sessions are very important so the clients can seek legal assistance to know what the options are available to them. So we can see in our situation here, the client here was adamant on going through litigation in the beginning, and then her counsel advised her that it's better to seek a settlement through conciliation as it is the best ADR mechanism for the labor-related issue. Here, the client learned the benefits of conciliation because she came to the counseling session and communicated with her lawyer, and she cleared all her doubts regarding it, which she wouldn't have known otherwise. So here she can finally acquire the advantages of conciliation, which are, firstly, it offers a more flexible alternative for a variety of disputes, whether they are small or large. And secondly, it obviates the parties from seeking recourse to the court system. Thirdly, it reserves the freedom of parties to withdraw from the conciliation without prejudice to their legal relationship at any point of the proceedings of the conciliation. Fourthly, it's committed to maintenance of confidentiality, which means that whatever information that they exchange between each other, any offers that they make, and solutions that the conciliator arrives to are all within the confidentiality, and it's between the parties and the conciliator themselves. Fifthly, it is a cost effective and produces a quicker resolution of disputes. And most importantly here, as our counsel mentioned, it maintains the relationship between the parties. So it's very beneficial for businesses and business employees and employee relationship. Lastly, there is no scope for corruption or bias here. We hope that our session was helpful. Thank you.
Good afternoon. I am Vidya Selvamony from 10th semester CMRU School of Legal Studies. Along with my fellow batchmates, we're gonna present here and second series session on client counseling and alternative dispute resolution. This informative session will be on arbitration. Let us understand first what is arbitration. As we all know, there are various modes to resolve disputes inside court and even outside court. Arbitration is one of them. Arbitration mechanism is a process of handling the disputes to the one or more party, which is an independent party known as arbitrator in an arbitral tribunal. Arbitration is governed by Arbitration and Conciliation Act 1996. Here, in this session of arbitration, the facts are there is a client who is approaching an advocate. The client is a builder and has entered into an agreement with cement manufacturer and has incurred some losses under this agreement. And they have incurred a dispute between them for which he is approaching an advocate. Here, the role of advocate is enacted by Thomas, and the role of client is is enacted by Clint. And here we start, the client is approaching an advocate.
Good evening, sir. May I come in?
Good evening. Please be seated. How can I help you?
Yes, sir. I'm John Kuruk. I own a construction company by the name of Confident Builders, with its head office in Kakinad, and I stay at the asset homes in that vicinity in Seaport Airport Road. So I had made plans for 8 villa project at Info Park, and we started work last May of 2020. And before that, I got into a contract with one Mr. Abel Matthews, who has a cement supply chain here in Kochi with his head office in Revipuram. So coming back, so about Abel Matthews, me and Abel Matthews go way long back. He's more than a friend than a business acquaintance. So coming back to the subject matter, we got into contract for a supply of 400 bags of cement per 1,000 square feet, and each villa of mine plans is 2,000 square feet. So that's 800 bags of cement per villa, and that's 6,400 bags in total. So approximately the capital in the contract was about 32 lakhs for the 8 villa project. And the contract was made by one of our close friends itself. He's also my business partner in the Confident Builders group, and everything was fine at the initial start of the project. So till about May of 2021, everything was all right. But after that, there was a delay of shipments, and I had told him once and twice that I need to get the shipments on time. Only then I can finish the project before the timeline. And because we have a lot of potential buyers also waiting as soon as we open our projects to the public, So. And he told me that it was because of the pandemic that the supply is less, and because he couldn't get the hold of the supplies himself, because he's not a manufacturer, he's just a supply chain. So when the last 4 houses have been constructed is when that delay was happening. And I excused it because he's a close friend of mine also, and we can understand with the pandemic and all that. But I think it was for the last 2 houses is when me and my chief engineer, which was about 1,600 bags of cement, that we noticed that the whole quality of the cement that we were getting was very low. So I didn't want to continue that project, further. I didn't want to risk that thing. And I tried to get on call with him, and I tried to make right the issue, but I couldn't get a hold of him at that point of time. So I got into contract with somebody else, this Amitabh Cements that I got. And this 1,600 bags, the last few bags also I paid for. I paid about 8 lakhs for that. And even though it's sitting idle in my warehouse, I haven't used it, and he hasn't even come to take it back, or he hasn't reimbursed me. So that's my situation that I'm in at the moment. So I don't know what to do about this. I don't know how to go ahead with this. So my partner suggested that we look at this legally. So that's why I thought, and they referred your name because you had done a few projects, and you had done a few hearings to the asset homes, if I'm right. So that's how I thought I'll come and see how I can go about this legally and make right this issue. So these are the facts. These is what the circumstances that I've gotten myself into. So how do we proceed with this? That's what I'm here for, sir.
Okay, John, I understood the basic facts that you're mainly told. So I will just brief out what are the exact thing that you just told me. So basically, you just own a construction company, and one of your close friend is Abel, who mainly supplies cements to your company. The things were mainly going smoothly between you and Abel. So after which he mainly started giving excuses, and the production and the supply was not sufficient, and he was not supplying on time. And the products that he mainly supplied was mainly of a not good quality, which mainly led to loss that is mainly inquired by you, and which mainly lead to the certain losses which mainly cost you in losing one of the big clients. So
Yes,
this
sir.
is the basic of the facts. But one thing that you told me was that there was an agreement which was mainly made between you and Abel, in which it was mainly made by a third party. So I just need to see the agreement in order to suggest a legal remedy that is mainly available for you.
Yes, sir. This is the agreement.
Okay, okay. So John, while going through the agreement, I mainly found that there is an arbitration clause which is mainly mentioned in this agreement. Like
Ex-
in that arbitration clause, it is mainly stated that if any dispute it is mainly happening between you and Abel, the matter has to be decided or it has to be resolved through an arbitration method only.
Come again, sir. An arbitration. What's like I stated, this was made by a third party, so I trusted him with it, and I just put my signature. I just knew the amount of bags and how much I have to pay. I didn't go through it thoroughly. I was busy at that moment. So can you explain what is this arbitration that you're talking about?
Yes, John, like it is clearly mentioned here that there is an arbitration clause, which is mainly mentioned here. So I'll explain to you what is basically an arbitration. So arbitration, it is a process which is mainly a contradictory to litigation. So it is a process in which a neutral party will be mainly appointed as an arbitrator, which is mainly try to resolve between the dispute that is mainly between John and Abel. He will try to resolve the dispute between you two, and he will be an arbitrator, and he will mainly pass an award which is mainly known as an arbitral award, and he will take a decision which is mainly unbiased decision which is mainly beneficial for you both parties. And it is a process in which you don't have to go to the court, you don't have to go through the litigation procedure, anything like that. And arbitration is only possible when the parties to a civil dispute agree to refer the matter to an arbitrator. So I think you got an idea about what is arbitration, what is all about.
Yes, sir, I got a brief understanding of the same, but can you further my understanding into the procedures and how this is conducted as we follow through with it?
Sure, John, I'll explain to you what is the exact procedure that we need to follow. So in arbitration, which mainly starts by initially sending a notice to the opposite party to whom a dispute, it is mainly there. So you are intimating the opposite party by sending a notice that you are planning to start an arbitration proceedings. So initially, after which, the main step of the arbitration, which mainly starts. So there should be the arbitration venue, what is the language used, what is the fees required, everything has to be fixed. After which, you will file a statement of claim. Then, after which he mainly required in order to file a written statement by which he will mainly counterclaim that one, or he will state the fact that he just want to tell. And if necessary, there will be an interim measure which mainly been supplied or which has mainly been published. Interim measures will be published. So after which the main proceedings it mainly start. So there will be a hearing and written proceedings which mainly start. After which the court will go through the evidences that you both will mainly submit. You might have this contract agreement, all this, everything will be, evidence will be there, right? So that you need to submit. After which, while going through entire facts, by studying the entire facts, the court will mainly go through the arbitral award will mainly be passed. And this arbitral award will be final and it will be binding. And one more thing, please do note, in case of settlement, the settlement award shall be passed or it should be issued in terms of the agreement that was mainly passed by the parties. So I think this is the procedure that we need to follow. Likewise, you will be able to know what are the details of the procedures, everything like that.
Yes, sir, I understand. I just picked up from your conversation right now, even though it was very clear, about the process and everything. And you did mention about the unbiased third party called as the arbitrators. So, what's the process? And you told about appointing them and all. So, if you can brief me over the procedures on that appointment, I think I'll have a better, clear view on that.
Sure, John, I'll explain to you what is the actual procedure for appointment of an arbitrator. So, any person, please do not, any person of a nationality may be appointed as an arbitrator unless contrary intention it is mainly expressed by the parties. A party is free to agree on a procedure for appointment of arbitrator that is mainly mentioned according to the section 11 of the Arbitration and Conciliation Act, and which mainly deals with the appointment of an arbitrator and arbitrators. So a party, if they mainly fails to appoint an arbitrator, so you can appoint an arbitrator, Abel can also appoint an arbitrator. There will be a third neutral party which may be appointed as a third arbitrator, which will be mainly acting as a presiding arbitrator. So if a party fails to appoint an arbitrator in accordance with the third arbitrator, that is, within the 30 days from the date of receipt of a request to do so from the other party, two appointed arbitrators and the third arbitrator, within 30 days, it shall be appointed by the request of the party by the court. So that is, it can be mainly by the Chief Justice of High Court or any person or instituted designated by him. So these are the basic procedures that is mainly required to be followed while we are mainly appointing an arbitrator. So as I mentioned, it is mainly described in Section 11 of the Arbitration and Conciliation Act.
Okay, so I understand that. So you told me myself or Mr. Abel Matthews can appoint an arbitrator. So are we just am I going to should I just appoint an arbitrator, or are you going to assist me with it?
So John, I can assist you in appointing an arbitrator, but there will be an impaneled advocates or there will be an impaneled arbitrators who are mainly specialized in different fields who will be appointed. I think now you're clear about the appointment, everything like that.
Yes, sir. Yes, sir. So this relief that we were talking about, this loss that I've incurred about, 8 lakhs with those 1,600 bags of cement, and also the timeline that's been shifted because of his negligence and the quality that's been deteriorated and the mind that he's put me through, like now I have to find another cement supplier and all of those. So this relief that you're saying is binding, is legally binding, right? That as a court judgment.
Yes, John, like the arbitral award, it is mainly legally binding as a court judgment, because arbitral award, it is a decision that is mainly passed by the decision of an arbitrator. So it can mainly have a relief regarding different remedies that is mainly based on the issues of dispute that is mainly about money, injunction remedies, incentives, etc. And the arbitral award of final, and it is mainly binding in an arbitration. So all these things, the decision that was mainly made by the arbitrator is mainly final, and it is mainly binding as a court judgment. There is nothing to worry about that.
Yes, I've understood the advantages of arbitration, and I understand. You gave me a much clear view of the same. So how much is this arbitration going to cost me, and how is it like, is it going to be more expensive than litigation, or can you just brief me on that?
So according to the Arbitration Conciliation Act, according to the 4th schedule, okay, so there will be a different categories in which how your property it is, how your claim it is mainly valued, and how it is the fees of the arbitration will be charged. So here the claim amount that you mainly charge, it is almost like 8 lakhs. So the amount that you need to pay as a fees for arbitration will be like 45,000 plus 3% of the claim amount. This is the fees that is mainly required that you need to pay for an arbitration proceedings. And my fees will be separate from that. My fees will be like 4,000 per counseling that you need to pay now, after which you may be pleased to leave if you don't have any doubts.
Yes, I think from what I came here for with my problem, you've given me at least an insight of how I should, forward this in the coming days or so. And anything else, we'll definitely keep in touch, sir. I'm very glad. I really appreciate you taking the time and explaining very in depth about, the advantages of arbitration, and that there was an arbitration clause that I seem to have missed in the first instance. So thank you, sir. That was really insightful.
John, do you have any more doubts to be clarified?
No, sir. I think I got what I came here for. So
okay, John. Okay, John. Then it's fine. It was nice meeting you. Thank you once again.
All right, sir. So I'll just pay the receptionist did brief me about the fees, so I'll just do that on the way out, and we'll keep in touch. Yeah.
Do that. Okay, then. Fine. Nice meeting you.
All right. Thank you, sir. Thank you. Thank you for your time.
Thank you.
Good afternoon, all. I'm Aparimita of 10th semester BBLLB, and I hope to like this session of client counseling. I hope through this role play, you could understand what is arbitration, what is the process, how the arbitrators are appointed, what is their fees, and last but not the least, what are arbitral awards. Through this video, we understand that the clients have an alternate dispute resolution mechanism in the form of ADRS, which is just in the form of arbitration, which is just as equally binding as a court's decision. Arbitration is not only cost and time effective, but if the parties wish to keep the entire process private, it can be done. And the arbitrators can make sure that all the information that is shared remains confidential between the parties. Arbitration also allows the client to choose their own venue at their own comfort, and it helps the client save their time and money as compared to a court litigation. By assisting the client in choosing arbitration over litigation, the advocate not only helps the client save time and money, but also reduces the burden on our judiciary. Thank you.
Good morning. I am Vidya Das from 10th semester CMR School of Legal Studies, presenting here third session of client counseling and alternative dispute resolution. The presentation emphasizes on importance of mediation. Mediation is a way of resolving conflict where two or more parties decide to reach an agreement with the support of third, neutral party that guides them through the process. Mediator is not a judge, but rather the facilitator that helps the parties to communicate and find common grounds. Now, the facts of the present session is that Mr. Raj Goyal, who has conflict with his wife, due to which his wife left her matrimonial home, is approaching an advocate for help. Here, Aarti is enacting role of advocate, whereas the role of client is enacted by Chaitanya Goyal. Let's begin the session now.
Good morning, ma'am.
Good morning, sir. Please have your seat.
Thank you, ma'am. It has been 3 weeks since we sent a legal notice, and I haven't received any update on that.
Sir, actually, we have got the acknowledgement in RPAD. I believe that Ms. Kapoor has received the legal notice, but even I haven't received any reply from their end.
Okay, so now where will be the filing of the case?
So, sir, like I mentioned last time, so since your wife hasn't replied to a legal notice and your matrimonial home is also here, like previously you both lived together in Bangalore, and your place is also here, we'll file in the Bangalore family court.
Okay, so what happens next when I institute the case?
So once we file this case in the family court, what happens is there is a court annexed mediation. So basically in this process, the case will go to family court, and then from there it will go to the mediation, the Bangalore Mediation Center. There, they will appoint a mediator. So generally a mediator is a third party. And basically what they try to do is they assist you so that your wife and can speak to each other in order to come up with a solution, and so that you can talk and set aside your differences. And but rest assured, everything in the process will remain confidential, and also it will be an obligation for both of you to attend the first meeting. And post that, the continuation of the process, that is the mediation process, will depend upon your mutual acceptance. So even if one of you does not want to go ahead with the process at any point of time, we can discontinue it.
Okay, ma'am. So you talked about the mediation process. I understood the process. So can you tell me who appoints the mediator and the role of the mediator?
So, sir, since we are filing in Bangalore, so your case will go to the Bangalore Mediation Center. So the director of there will appoint a mediator to your case. So generally a mediator, they are a neutral third party, and they try to facilitate your session. So they'll basically help you talk to each other and come up with a solution to your problem.
Okay. So ma'am, can we have a private session with the mediator, me and my wife?
Yeah, sure, definitely. If you are the mediator, feel the need to do so to place your problems, you can have a private caucus session with the mediator, Also, again, the mediator also will tell you the entire process of how the mediation will go in that session.
Okay. And how many days will it take for the mediation process?
So the process generally it goes for 60 days. Again, like I said, first sitting is mandatory. First on which how you go ahead with this around like 3 or 4 sittings, you can finish it off. Depending on how your process goes, it can extend, but maximum is 60 days.
Okay. So is there any fixed procedure for the mediation as it follows in the court? Like there's a fixed procedure for court?
So, sir, no, sir. In this mediation process, there's no stringent procedure as such we follow in a mediation. However, there are two methods of mediation, that is facilitative and evaluative. So here, in your case, the mediator will mostly be adopting a facilitative mediation method because in this process, what happens is it helps to facilitate communication between you two so that you can it would help because it would make you understand each other's perspective and position and interest in relation to the dispute. So this will make you help arrive at the solution.
Okay, I understood that. So what happens if I don't accept the decision by the mediation?
So, sir, in the mediation process, the decision is not binding like that of a court. So only if you and your wife voluntarily agree to it, it will be binding.
Okay, and what if the mediation fails?
If we do not succeed, like if we do not come up with a solution in the mediation, the case will go back to the court and it will go as per the court proceedings.
Okay, so what is the procedure in the court if I don't go to the mediation?
Okay. So what happens is if the counseling session is successful, then based on your settlement terms, the court will pass a decree accordingly. But if it is not, then based on the counseling session, the statements made, keeping in view of the conduct of the parties, the judge will grant a decree for your case.
Okay, ma'am. So I want to proceed with the case now. And what will be the fees for the procedure?
So, sir, for this session, I will be taking 2,000 rupees for this counseling session. However, if we are going to institute the case, then my professional fees will be 6,000 rupees and office charge will be 2,000 rupees. I would still like to say, so please think over, and if you need more time, please take your time, and we have time to file the case. So please think upon it before we go with the case.
Okay, sure, ma'am. I would like to get back. I will get back to you on this.
Okay, sir. Let me know your decision, and post then we'll have an appointment for institution of the case.
Okay, thank you, ma'am.
Thank you, sir. Thank you.
Hello, my name is Neha Sengupta, and I hope you liked the video presentation given to you by my fellow mates on mediation. Through this video, I hope you all understood what is mediation, who are mediators, how are they appointed, what is their role in settling a dispute. When we saw this video, and throughout this video, we understood that it is not only courts litigation that a client can approach whenever there's a dispute, but there is also an alternative dispute redressal mechanism, which includes mediation too. Mediation is not only cost and time effective, but it also provides a win-win situation. So when I speak about win-win situation, I mean that whenever we approach to the court for any matter, either one party loses and the other party wins. However, in mediation, both the parties come into a settlement, and the outcome which is obtained is beneficial for both of them, resulting in a win-win situation. Mediation not only resolves the dispute, but it also resolves the issues which led to the dispute or misunderstanding. A mediator is a third party, and it's a neutral third party who helps and guides both the parties in communicating with each other and guiding them towards getting the desired resolution. The entire process of mediation is confidential, which makes it much more relaxed process, which helps the client to open up about their issues to the mediators, which helps the mediators to gather better and more information, and which ultimately helps the mediator in helping and guiding the client to reach the desired resolution that they want. Lawyers and advocates of today should emphasize more on mediation and also on the other ADR mechanisms because it provides a speedy remedy. With more and more awareness about the ADR mechanism, it will not only help the clients get the satisfactory resolution, but it will also lessen the burden of the courts. I hope through this video, you all could learn more about mediation. I thank you all for watching this video.
Good morning. This is the fourth video of a client counseling session in the Alternative Dispute Resolution System series. I am Blessy Ann, and today my friends and I from the 10th semester are putting forth a client counseling session emphasizing the Lok Adalat mechanism under ADRS. A little insight on Lok Adalat. The Legal Service Authorities Act 1987 was enacted to constitute legal service authorities for providing free and legal services to the weaker sections of society. They were also to ensure that opportunities for securing justice were not denied to any citizen by reason of economic or other disabilities. Lok Adalats were organized to ensure that the operation of the legal system promoted justice on the basis of equal opportunity. The system of Lok Adalat, which is a mechanism for alternative dispute resolution, has proved effective for resolving disputes in the spirit of conciliation outside the courts. The system of Lok Adalats is mainly based on compromise or settlement between the parties. Lok Adalats are also given the power to decide the cases based on merits if the parties fail to arrive at a compromise or settlement. Now let us proceed to the facts of the case. An accident took place at Nehru Circle, Bengaluru on Friday night, the 13th of June at 10 p.m., involving a female rider who is the victim and a man in his early 30s who was driving a tempo traveler. The road was a narrow one with dimly lit streetlights. The man was overspeeding and the girl came from the opposite direction, and a collision between them happened due to the fault of the man who was speeding. As a result, the girl suffered serious injuries to her back and arms. And post the accident, a verbal argument took place between the two parties, after which the girl threatened the man with legal consequences, to which the man was ignorant and fled the scene. The girl had to go to the hospital all by herself and bore the entire medical expenses. The injuries on her back were treated and those healed in a while, but the girl's injuries on the arm were of a permanent nature and cannot heal. In addition, the girl's bike was damaged and those expenses were also borne by the girl. The girl approached her advocate for legal advice, and subsequently, a case was filed by the girl under the relevant sections of the Motor Vehicles Act 1988. The case was referred to Lok Adalat, and the advocate advised the client regarding the same. Here, Merin is the counsel, and Gopika is the client. Let's proceed to the scene where they meet for the second time.
Hello, madam. Hope you're doing well. Your case has been allotted to Lok Adalat that is scheduled to happen this Saturday. This meeting has been arranged so that we can decide the way forward with your case.
Hi, ma'am. I'm doing good. I hope you are doing good too. So, what is this all about?
Ma'am, your case has been transferred to Lok Adalat as the opposite party had made an application to the court seeking for a settlement through Lok Adalat, and the judge was satisfied that there are chances for settlement, and he strongly asked me to go for it. So I agreed to it, madam.
But, ma'am, what is this Lok Adalat?
Ma'am, to explain in simple terms, Lok Adalat means people's court. It is referred as an alternative dispute redressal mechanism. It's a forum whereby dispute or cases which are being pending in the court of law or in a pre-litigation stage can be settled amicably or even compromised amicably. So in our case, as the opposite party had made an application to the court seeking for a settlement through Lok Adalat, and the judge was satisfied there are chances for settlement, and he strongly asked me to go through it. So I agreed to it, madam.
But, ma'am, is it necessary?
Yeah, I have agreed to it, madam, and the decision has been made by the judge.
Let's try to avoid it. I want to go to the court and get justice.
Ma'am, to understand, we cannot avoid it. We have to attend it. And also understand that the benefits of Lok Adalat are quite over litigation. There is no court case to be filed if you've taken a matter to before the Lok Adalat, and also the mechanism and the procedures are very speedy, and the redressal can be obtained very soon. So I seriously suggest you, ma'am, the Lok Adalat would be far more better than litigation.
No, he's a criminal. He deserves to get punished. So let's not settle this matter.
Ma'am, I understand your anger and frustration, madam, but let's admit it, it was an accident. And if he is willing to settle the matter, it's a good idea, and I will highly recommend it that we are in a good position to settle it, madam.
But he misbehaved with me, ma'am. How do you expect me to settle this matter and set him free? I deserve justice and fair play.
What do you mean by misbehavior, ma'am? What happened?
After the crash, he verbally abused me by putting the blame on me and accused me of playing the victim card. In addition, he threatened me that he would physically harm me and my family.
So, initially, madam, you should not have hidden these details from me. I have assured in our previous meetings that everything we discuss regarding your case will be highly confidential and just between two of us. There is no need to hide things from me. And let me tell you one famous quote that never hide anything from a doctor and a lawyer. They're going to protect you. So this is very serious, madam. But I assure you that he is not going to harm you and your family.
Yes, ma'am. I have now shared all the details with you with regards to this accident, and I have complete trust on you. Please don't think otherwise.
I would still highly recommend you to settle the case to Lok Adalat, madam. And my proposal for the settlement is rupees 3 lakh. After having considered your situation, are you okay with this amount? Why I am persuading you is because we are in a good position as he wants to settle the matter. So we have a high leverage. And so we can demand a huge amount, and so he will not refuse it. But on the other hand, if you refuse to settle and wish to proceed with the case, as I have mentioned before, it will take a very long time, ma'am. And you will have to keep visiting the courts every now and then. And that will be an unnecessary headache for you, madam.
Okay, ma'am. If you insist so much, I'll consider going ahead with. You are right here, and the amount seems reasonable. I trust your experience, and I know that you will have my best interest at your heart.
I am glad that, ma'am, you have faith in me. You will not regret for this. Do not worry, madam. Fighting court cases is a daunting task. So wherever we can settle amicably, we should always go for it. I do not mind fighting a case as many long years, how much it goes. I will get my fee from you, but that's not the right thing to do. My conscience will not allow me to do so. My job is safeguarding the best interests of my client and not making money. And that's not my goal to make money. My goal is to get justice for my clients. And in this case of yours, the settlement is the best recourse for you, madam.
Okay, ma'am. I understand and I appreciate your approach towards your profession. Not everyone is like you. Most people are money minded now these days. I don't know what to say, ma'am. I'm lost for words. I'll go ahead and settle this matter at Lok Adalat if I'm getting the amount what we have agreed upon by that man.
Okay, ma'am, that's great. I assure you, no Miss Aishwarya, my colleague. She will be there for you throughout the Lok Adalat session. She knows your case in and out, and she will advise you thoroughly regarding the settlement that we have discussed. You can pay the decided fee to Miss Aishwarya.
Yes, ma'am. I know Miss Aishwarya. She was there with us in the initial hearings of my case. I will pay the decided amount to her.
Okay, ma'am, that's fine. Bye, madam. See you at the court on Saturday. You have my number and call details. Call me at any time if you want any kind of help from me.
Bye, ma'am. We will meet at the court.
Okay, thank you.
Thank you.
Good morning, all. I, Ayush Panigrahi from 10th semester BBA LLB. I am presenting the conclusion of the series. I hope this series helped you to understand what is Lok Adalat. Through this video, we understand that Lok Adalat is one of the ADR mechanisms where disputes or cases present pending in the court of law or at pre-litigation stages are settled amicably. Lok Adalats have been given their statutory status under the Legal Service Authority Act 1987. Under the said act, the awards or a decision made by the Lok Adalat is deemed to be a decree of a civil court and is final and is binding on all the parties. No appeal against such an award lies before any court of law. But if the parties are not satisfied with the awards given by the Lok Adalat, they are free to initiate litigation by approaching the courts. At last, Lok Adalat delivers inexpensive and fast justice. They help in reducing the workload of other courts, which enables them to look into more serious matters. This results in reduction of delays in higher courts. Thank you for watching our videos.